Hello, everybody. Welcome to today's OFA member webinar. My name is Ben Lafort. I am a senior policy analyst with OFA. And with us today is Andrew Fortis. Andrew is a founding partner of Hummingbird Lawyers and is responsible for its real estate and business law groups. I'll read a little bit more about Andrew's bio so everyone has a familiarity with him. Andrew, after completing his Bachelor of Arts degree in political science from York University, obtained his doctorate from Michigan State University Law School in 1999, and was called to the New York State Bar that same year. After completing his U.S. law degree and New York license, he returned to Canada and was called to the Ontario Bar in 2002. After spending some time on Bay Street, he started his own journey building and growing what is now Hummingbird's Lawyers LLP. And continuing his passion for real estate law, he obtained his Master's of Law in Real Estate from York University and was designated by the Law Society of Ontario as a certified specialist in real estate law in 2016. Andrew presently tutors for the LSO Bar Administration course and sits on the past chair of the Ontario Bar Association's Real Property Executive. He's a regular speaker for the Law Society of Ontario and Ontario Bar Association, and has been recognized as an expert in real estate by the Superior Court of Justice. Andrew's practice consists of all things real estate, from assisting first-time buyers purchasing their first home to complex title matters involving easements and adverse possession claims. He regularly acts as a commercial transactions, including the purchase, sale, and refinancing of buildings, commercial leases, and land assemblies. When he's not working, Andrew can be found coaching his son's minor hockey teams and golfing. And I would like to welcome Andrew. Thank you so much for joining us today and giving us this presentation overview on easements.
Thank you so much, Ben. I appreciate it, and it's nice to meet everybody digitally, so to speak. So today we're going to be talking about easements. It's just an overview. The book of easements was actually just produced in 2023 by a fellow who has since passed. His name is Craig Carter. That book is about 2,000 pages. So I'm going to try and condense the 2,000 pages into our 1 hour today. So as Ben mentioned, I'm a founding partner of Hummingbird Lawyers LLP. I am responsible for the firm's real estate and business law groups. My practice is really focused on acquisitions, dispositions, and financings of businesses and real property. I do a lot of leasing. I do a lot of mortgage enforcement and litigation that arises, pardon me, out of land disputes. And my favorite actual part of the practice is advising on title matters that are complex, typically involving easements and adverse possession claims. So today's objectives is really, look, I know I'm speaking with the Ontario Federation of Agriculture, and I can assume that you may either own or lease large tracts of land, which may require passage over other parties' lands, sometimes a right-of-way, which is a particular type of easement. Thus, you might be engaging in the use of an easement with or without your knowledge. And my role today isn't to give you a full legal dissertation on easements. However, it's my goal and objective today that at the end of the session, you're going to either know a little bit more or remember one of the following, which is a better understanding of easements and how they impact properties. What are the 4 characteristics of an easement? How to distinguish an easement from other rights? Understand the 4 ways that easements are created. Know what amounts to a disturbance and those remedies for disturbance of easements, and how easements are extinguished or lost. So let's start off with what is an easement. In essence, it's a privilege of imposing a certain burden on a grantor's land for the benefit of the adjoining grantee's land. One of the examples I usually give people is a Rogers cable box that sits in the front of a residential neighborhood on someone's lawn. Rogers doesn't own the land upon which the box sits, but it owns the box that sits on the land and has the right to enter the land for the purposes, typically whatever it's written, for repairing, maintaining, replacing, servicing that cable box. Now, Rogers has the privilege of leaving a box on someone's property and the right to enter it when it wants, and the landowners who own the land can't say much about that use. In a nutshell, that is an easement. Now, how do you recognize an easement? If you look at your property deeds, you'll see either a TW or an ST. If you see a TW, it means together with, and if you see an ST, it means subject to, and that's usually found in the thumbnail of the legal description, or will be contained inside the regular document, in the registered document on title, which will include language that says subject to, or together with, or reserving. On a survey, if you have a survey, it will show a part of the survey and it will say easement on that part. You'll need to pull that instrument that's registered on title to see exactly who the parties are, the scope of the easement and the duration of that easement, and any other details that are associated with it. Generally speaking, easements run with the land, so it remains on title after the property is sold and transferred. And if we look to the slide, the easement is a right of another owner of a benefit. Whoever has the benefit is called the dominant tenement, and if you have that right on somebody else's property, they are called the servient tenement, which is why you get the ST, the subject to, which is the servient, and the together with, which means the dominant. And the benefit afforded to the dominant tenement is the right to prevent the servient tenement from not to do something such as build a structure on a driveway if it's a right of way. And what's interesting about real property easements is that they don't involve ownership of any part of the land, but only the right to use. But this right to use is greater than a mere license. Just to be perfectly candid from the beginning, easements are not straightforward issues. I do a lot of easement disputes, and they do require a full title search and a history of the use prior to being able to come to a definitive conclusion as to what the rights and obligations are surrounding that easement. So I've thrown in two cases. You can write them down. There's a service put out by the province of Ontario. It's called Canley. It's free. It's online. These are two cases that give fuller background on easements. They're great cases if you have any interest in that. The first case was a dispute between neighbors over the use of a single car driveway, and the use was given by one neighbor to the other by way of permission. And when the servient neighbor, the one who gave permission, sold, the new owner blocked the use of the other neighbor who was using it. And the case turned on the elements of prescriptive easements, which we'll discuss today, but it's an excellent case to read about the overall law on easements and that being a good neighbor will not forfeit your rights. The second case talks about abandonment of easement and the expiry of easements. A lot of people have questions on, if there's an easement, how do I get rid of it? And that case talks about that. And we're going to talk about that as well today. So when we look at easements, there are 4 elements that are required for every easement. First, there has to be a dominant and a servient tenement, meaning some parcel of land has to be the benefactor of the easement, being the dominant, and another parcel has to be the subject to, or the servient of the easement rights. The rights are not personal to the owners as they are attached to the land. Number 2, the easement must accommodate the dominant tenement, which means it can't be there for no purpose. The easement has to be for the reasonable use and enjoyment of the dominant lands. Number 3, the owners of the parcel must be different owners. Otherwise, there's a risk that the easement will be extinguished because they will merge together. Okay, because you can't enforce an easement right against yourself. And then fourthly, the right has to form the subject matter of a grant, meaning the specific portion of the lands which are being burdened and the benefit have to be made out, as well as the rights associated with the easement. If it's not 100% clear or defined, it doesn't necessarily mean that the easement doesn't exist, as the courts will interpret these provisions. Let's talk about the dominant and the servient tenement. As I stated earlier, for an easement to exist, there has to be 2 separate pieces of land that are involved. One is the benefiting parcel, so that's the dominant tenement, and the one that's subject to the easement, which is the servient tenement. These 2 pieces of land don't necessarily have to be right beside each other, which is called appertenant. The parties involved must intend for the easement to be connected to the land. And it's also very important to specify the piece of land benefiting from the easement in the agreement. And if the agreement doesn't specify, again, the court can use other evidence to figure out what was intended, because a lot of these easements gets registered. And like I say, they stay on title forever. And it's hard to determine what was the intended purpose, from 40 years ago. But of course, we'll look at evidence and figure out what the intended purpose of. And the reason why the courts will get involved is because easements are based upon equity, what is fair. So because they're based upon equitable principles, the courts will interpret what is fair and what isn't. Now, when we buy land, I'm an old school lawyer. So when you own land from heaven all the way down to the core of the earth, from heaven to hell. And generally speaking, we can do what we want with that land and airspace. I mean, sometimes when you acquire land, there's a crown patent, which are the originating documents, which grants land from his majesty to the initial owner. And within that crown grant, there's going to be reservations, usually for mineral rights. So if you dig in your property and you find the diamond of a basketball, don't get too excited, as that's most likely going to belong to His Majesty. The same thing, if a plane wants to fly over your airspace, they're not allowed to, unless there's an airport zoning regulation or you give them permission. So outside of the crown patent and outside of the bylaw restrictions, if someone wants to use your land, they need permission. To entrench the permission, easements are registered or recorded on title to the land, and subsequent purchasers take title subject to those easements, which are the permissions. The easement can be either positive, which allows the other party to do something such as travel, park a car, lay a pipe, or lay a cable. But the easement has to be a right. It can't be an obligation, such as giving them the obligation to repair. Now, this burden is imposed as a matter of law, as they're the ones that are using it, but you can't make a positive obligation. Now, some easements are negative, such as prohibiting the operation of some sort of activities, such as you can't build upon this. A conservation easement is an excellent example, or solar easements to prevent the blockage of sunlight. So negative easements are allowed as long as they can't compel anyone to do anything. So, how do you distinguish easement rights from other rights? So easements are commonly mistaken for other rights, such as a license or a profit ponda, which are rights to use someone else's land, but those rights are personal to an individual and not a land, right? And one of the most basic ways of thinking of a license is a ticket to a movie theater. That is a license that allows you to enter the movie theater, and it can be revoked very easily. Easements are not like licenses. They can't be revoked, okay? They can be, but not very easily, such as in the license. So when you're the beneficiary of an easement, it's your obligation to maintain it. The servient tenement cannot disrupt the right of way or prevent the use of it. And the dominant tenement cannot expand the rights which are granted in the easement. So if it provides you can park a car, the use at the time of granting the easement will be a continued use. It cannot be expanded to 2 cars without a new easement or without consent, okay? A profit ponda is a right to enter someone else's land and take something from it, like minerals, woods, or fish. That's a personal right. That's not an easement. And true easements allow you to do something, prevent something on someone else's land, but they don't guarantee that something will be done for you on that land. So you have to differentiate, is it a license or is it a easement? Now let's talk about how easements are created. They can only be created in 4 ways, either by way of an express grant, an implied grant, by prescription, or by statute, okay? There are no other ways for an easement to arise. So let's talk about express easements and grants, which is your more typical easements that are done. The first one is the easements are written and they're registered on title. And this is your prototypical easement. Once it's in writing, it's registered on title to both the dominant and the servient tenement. And disputes around these easements is usually done around their expiry, because they can be granted for life, for years, sometimes in smaller durations. And the one granting the easement must actually own the land granting it. So if you are a tenant of a property, you don't have the right to grant an easement to your neighbor. It has to come from the actual owner. And the easement has to connect to the benefiting land, such as a right of way, which will ultimately lead to one of the king's highways. And once it's validly created, it will pass on to subsequent conveyances and it will bind future owners. In terms of ranking the security of the right under an easement, this is a superior right. It is an excellent, excellent right to have if you have it. If your property is subject to an easement, it's it's got implications on value, use, its restriction. It really is a giving away of your property. So when we look at the easements, the express easement grants are to be written and registered on title. To create an express easement, the person granting it must have legal ownership of the land. If you're getting an easement from a corporation, you want to search that corporation, make sure that corporation is actually in existence, so it has the corporate capacity to grant the easement. If you want to enforce the rights of an easement, the person who wants to enforce those rights must show a connection to the recipient of the easement on the benefiting piece of land. It has to be formally documented, and a lot of them aren't. Some of them are just poorly drafted, which causes problems. And again, a document won't be invalidated for being unclear unless it's impossible to understand its meaning. The danger, of course, is you're off to court to get that interpreted, and it's very, very expensive to get those issues sorted out. You want to avoid court as much as possible. So the second way of creating it is an implied easement. The doctrine of an implied easement is an equitable one because we're dealing with easements which are in equity, and an easement will be found where it's fair or equitable to do so. So unlike an express easement, which is written and documented, an implied easement is documented, but it is claimed on the basis that the easement is implied. This is usually the case where one owner, they split their lots and they create two lots. And the property that is sold will come with easements that are continuous and apparent, which are necessary to the reasonable enjoyment of the property, which under the unity of possession, it previously enjoyed. So let's talk about a right of way as an example. So an owner has a large parcel of land that contains a road out to the King's Highway. They sever the lot. We'll call it the back lot, not the front lot, which is connected to the road. Well, when they sever that back lot and they sell it to the owner, if there's no access right to that to King's Highway, that property would in effect be landlocked. So the courts will say, well, with that grant, there had to have been an implied exit to the King's Highway. So that's when they talk about an implied easement. One ought to obviously would have been implied in that grant. So the doctrine is really based on the premise that when lands are severed, the grantor, severer, meant or implied to give an easement with the conveyance to the grantee. But to rely on the doctrine, there has to be a unity of ownership at some point in time, which intended to give the easement. Otherwise, the courts are reluctant to give a grant. So in other words, if we're going to look for an easement that's implied, we have to go back and search title to find out at one point, all this land was owned by one person. And as it got severed along the way, they must have intended to have access or to give an easement if it was necessary for the purposes of the use and enjoyment of the property, okay? And this is why it is very important that these documents get properly prepared and registered, because the dispute is never really as between the initial parties. It happens in the second or third generation of ownership where nobody really remembers, or they were using it for so long, but they forget what was implied and what they were meaning to do. So that's why you should have, if you're going to create an easement or get an easement, you definitely want it registered. You want to have specific language. Nice little plug for lawyers. You want it reviewed by a lawyer to make sure that those rights are permanent, because when you sell your property, you want to make sure that those easement rights are there for the future purchaser. Let's talk about prescriptive easements, which is the third way. So this is again a situation where there's no written easement, but someone has been using the property in a manner which would give rise to a prescriptive easement. A prescriptive easement can be defined to be title acquired by possession by virtue of the passage of time and in accordance with legal requirements. Think about somebody just traversing on your land over a period of time, because property owners have an obligation to secure their land and to inspect it. And so the legal requirement for the person making a claim for an easement by prescription, they have to prove that they've been using it for at least 20 years. So it's not as though you, as a property owner, you got to worry about 1 week's time, but over 20 years, you have an obligation to walk every inch of your property and make sure nobody's using it or making a claim to it. If the user has permission from the actual owner to use the property, then there will not be an easement by prescription, because in order to claim an easement for prescription, they have to think that they are the actual owner. They're using it under what is called the color of right. They thought this is theirs, or they have the right to do so. The other requirements for an easement is still needed. You definitely still need a dominant and servant tenement. You must have different owners, and the use must benefit another parcel of land to be able to form the subject matter of a grant. At common law, the way the courts have interpreted prescriptive easements was that it had to be used since time immemorial, which means you had to be using it since King Richard I's reign, which commenced on 1189. Now, the problem is America was discovered in 1492, so it's very difficult for anybody to establish that they were using it 300 years prior to the discovery of North America. So one of the other ways is called the doctrine of moss lawn and grant, and that falls under that, which is based on the assumption that there was a grant a long time ago, and that if the user has been using it for 20 years or more, it should be presumed that the easement was granted at some point in time, and the law will adopt this legal fiction that at some point there was a grant for the easement. And so that's where we get into the Real Property Limitations Act, and we'll talk about that next when we talk about statutes, where if you've been using it for 20 years, it will be given to you. And if you've been using it for 40 years, it is considered automatic. It's automatically yours. Now, this is a little bit beyond the scope of our conversation today because we're talking about easements by prescription at this time. If those were only allowed if your property was registered in registry. If your property was one of those properties that went through the conversion process in the mid-90s and onwards because the province wanted to automate all their parcel abstracts, they converted it from registry to land titles. Land titles does not allow for easements by prescription, so it's been abolished. It still exists for registry properties, which is about 3% of the total properties in the province. But if someone's going to be claiming an easement by prescription, the first thing we search is what was the conversion date, and if that property is land titles or registry. Because like I said, you cannot get it. You cannot claim an easement by prescription if the property is registered in land titles. And if it's a conversion property, that 20 years had to have occurred right prior to the conversion date. And you'll find that conversion date on your parcel abstract if you search it. So let's talk about easements by statute. This is the final way of obtaining an easement, and it's by law. The Land Titles Act and the Real Property Limitations are examples. One of the most common ways, and we talked about it, was easement by prescription, and that's done by statute, saying if you've been occupying it for a certain period of time, you're going to be given the rights associated with that easement. There's also the Land Titles Act, where the Director of Titles can register an easement on title. And when this is done, they're given a certificate. And so when would this come about? Let's assume for the moment, and I do these, you get a dispute for adverse possession, squatter's rights. And the squatter is ultimately successful. So what happens is, what if the squatter is ultimately successful, but that land locks the owner who lost their land to the squatter? Well, the Land Registry Office can impose an easement and grant a certificate of easement because it's going to be used to benefit the land. And also the Condominium Act also provides for the creation of an easement. So an easement can also arise by statute and where it's recorded in law. Now that we know how easements are created, and there's only the 4 ways for them to be created, we now get into the middle, the life cycle, right? We have the birth, we'll talk about the death of an easement. Now we're in the middle. And this is a good chunk of my practice. I get a lot of easement disputes, These disputes, when they arise, they're usually called disturbances because the dominant tenant's rights are being disturbed. And you know, some of the ones that I see, and my office is in Vaughan. We also have an office in downtown Toronto, but by being in Vaughan in York region, I also deal with a lot of properties up north. And so a lot of right-of-ways, a lot of water access, And sometimes those easements are blocked, and sometimes they're blocked by accident, sometimes they're blocked on purpose. Sometimes people expand the use of the easement. We're going to talk about that as well. And then the aggrieved parties sometimes take matters in their own hands, which is not a preferred route to take. And we're going to talk about self-help remedies. So let's talk about disturbances. Not every interference is a legal wrong. So I want you to think about a narrow right of way, and I'm coming down one, and another car is coming the opposite way, and I have to wait in order for them to pass us through. It's an interference, right? Because it's preventing my flow of the right of way, but that's a temporary disturbance. You won't get any remedy in court on that. The affirmative easements sometimes don't grant exclusive enjoyment. So some easements are exclusive and others are not, right? And just because you're granted an easement doesn't mean it grants exclusivity. Easements can be granted to others, and it's going to depend on the language contained in the easement. And you'll read it, it will say exclusive or non-exclusive, okay? And then easements may have specific prohibitions. And obstructing a public highway is a wrong if it's noticeable, but the same isn't true for a private right of way unless the obstruction is substantial. So in order to make a determination of whether or not there's a disturbance, you actually have to look at the language of the easement, determine its purpose, what was it granted for, and is that particular use being interfered with? And are there any restrictions on the use? Some of the ones I get in for the city of Toronto, it's a right of way, a mutual driveway, and people put out their blue bins or their green boxes, and they block it, and it prevents cars from coming in and out. Those are considered disturbances. Now, there's a difference between a private nuisance, which affects a person's property enjoyment, and the disturbing of an easement. So if you and I are neighbors, but we don't have easements, and I play my music too loud, or I'm engaging in activities which causes odors, and it goes onto your property and it's affecting you, okay, that would be called a nuisance, and you would sue me for a private nuisance. If I granted you an easement and I was interfering with your easement, obviously not through music or through odors, but let's say there's a right of way and I parked my boat trailer on it, preventing you from going in and out, that would be called a disturbance. Now, historically speaking, you would only get monetary damages for disturbances of an easement, but that wouldn't prevent the person from offending again. So if I use the example again, I park my boat trailer on the right of way. You get upset, you sue me, okay, and you sue for damages. Let's assume for the moment it's $300 because you were inconvenienced. Okay, I pay you the $300. There's nothing preventing me from going back the next day and parking the boat trailer on the right of way again. So what do you do in order to prevent me from doing it repeatedly? You get an injunction, okay? And that's a court order preventing me from doing the activity that I was engaged in. And if I continue with that activity in the face of a court order, you would have me under breach of a court order, which is never good, okay? So the only challenge, of course, is injunctions, like I say, are very expensive. In the case of interfering with an easement, it's treated as a nuisance, but the easement must exist prior to seeking a remedy. So if there is no easement, you can't sue for nuisance. Instead, sorry, you can't sue for disturbance, you got to sue for nuisance because there is no easement to begin with. If someone is blocking your easement and you consent to that easement, you may actually lose your rights. And we'll talk about, under extinguishment of easements, about abandonment of easements. And then if someone parts a permanent building, and I've actually had this, I have an easement where somebody actually constructed a 3-story building over an easement. We got to get an injunction to move that building, and that's going to be difficult to get unless it materially affects the property. Think like garages sometimes when they're built on top of right-of-ways. If you can still get through, you're going to end up getting monetary damages because the courts are going to be reluctant to move an entire structure. And And so it depends on the level of disturbance. Also talking about disturbances, some of the ones we see is people go and they buy cottage properties. And as you know, if you have cottage properties, there's not always deeded, there's road access to a right of way. You may not own the roadway. And so some of the complaints we'll be getting is somebody buys a cottage and they use it for Airbnb. And all of a sudden, that road is being used by lots of people, lots of travel, and it's interfering. So that is also a disturbance because it is expanding the use of the easement. And we've seen cases like that in our office. And then the last point, even without legal title, a person in actual or constructive possession of the servient tenement can take legal action against someone claiming an easement. So if you're in possession of the property, and I want you to think squatters, it's actually a quite mind-bending exercise. So you own the land, I'm squatting on your land, and someone's making a claim for an easement on the land on which I'm squatting. I can still bring an application to prevent that individual from using the land upon which I am squatting. So if I don't know if there's a squatter out there, they have those rights as well. So when we have a disturbance, how do we deal with it? So there's really two ways, there's civil law and then there's street law. We don't dispense in street law and we don't advocate for it. So street law is really abatement. It's a self-help remedy. Okay, so an abatement of a nuisance is a remedy by which the law does not favor. They don't like self-help. Okay, it's when the one of the parties goes in and forcibly removes the blockage. So I have a right of way. You park your car on it. I get your car towed. They don't like that. Or you build a fence to block it, and I knock down that fence. The courts don't like it. They want you to get a court action. And so that's relief by action, which is the preferred remedy. And it can produce damages, which is a monetary benefit, or really what you're after is an injunction to prevent further breaches of the terms of the easement. Like I say, injunctions are not cheap processes. It leads to an economic issue. I've had clients who have had easement issues. And I can tell you, York region, if we have an easement dispute, and it goes the distance. I mean, we go to a judge's decision, we don't settle it between the pleadings, between examinations for discovery, surveyors, experts. It could be upwards to $80,000 to $90,000. They're not cheap procedures. And if the property's in downtown Toronto where everything's selling for $1,000 a square foot, it might make sense. I've had properties up north where the dollars just don't make sense. So it's also an economic decision as to how you want to deal with disturbances because they can be very, very problematic. So that's how we deal with our disputes as we go through these. And again, they're not cheap. And my advice is always speak to your neighbor, try and work it out, see what you can do. And if that doesn't work, then that's what the courts are for. That's the ultimate resolution for disputes. So let's talk about the death of an easement. So we know how they were created, talk about the lifetime and its death. So not all easements are forever, okay? They can be extinguished 5 ways: by way of an express release, release and abandonment, unity of ownership, statute, and duration. Okay, so let's talk about the first one, express release. If the easement is going to be released expressly, it means it's got to be done in writing, which means you need the consent of all interested parties. And when we talk about interested parties, not only is it the owners, we're talking about spouses, we're talking about lenders, we're talking about tenants. Anybody who has an interest in the land that would otherwise have the benefit of that easement has to consent before it is, what we call it, ruled off of title. Okay. And if everyone does consent, it gets registered in the land registry office, and then that easement is extinguished from title. The release and abandonment, it's similar to an express release, but the release and abandonment is a document that is registered after we've gone to court, okay? So if there's been a case we had 2 years ago, we had a client who enjoyed easement rights when they bought the house. However, there was a garage that was built on a good chunk of the easement, and that house was there for 50 years. And the court said, well, you guys didn't complain about it. Obviously, you didn't need it, and therefore it's deemed to have been released. And so what happens is you get a court order saying that it's been released and abandoned, and then that court order is registered under a release and abandonment on title. So that's the second way of losing it. The third way is the unity of ownership. We talked about this earlier. It's if I own a property and I have the benefit of an easement, and you're the serving tenement and you're next door, and I buy it, those two properties merge. There's no longer a need for that easement. So it's going to be extinguished, and that's done by operation of law. The fourth one is by statute, and that's with the passage of time. If we're inside registry and there's an easement, anything that is registered has to be recorded every 40 years, and we'll talk about that. And that's another way that an easement could be lost. And then the fifth one is where the easement itself contains language that has a set expiry date. This easement will be good for 10 years from the date of registration, sometimes 20 years, whatever it is. There's a time period that is specified, and it will ultimately pass. So let's talk about the express release again. So if it's going to be released expressly, it means it's going to be done in writing. You need the consent of all interested parties. If it isn't done expressly, you can probably try to get it by way of implication, which is like we talked about, which is obstruction. Okay. For an express release, you got to prepare the paperwork. You got to send it out to everybody. They actually have to sign, and you have to enter into the land registry office. The lawyer who is registering that release of easement, that express release, has to make something called a law statement. And if they lie, they can actually lose their law license over it. And part of that statement is they have received the consent of every party that has an interest in the land. So that's one way of doing it. And we've done a few that are on consent. The second one is the release and abandonment. Again, we talked about where it was blocked. Okay. Or sometimes it's not needed anymore, right? And so these are done without the consent of parties. Okay. And the burden of proof showing that the person it's been abandoned is the person who's claiming it. So if you're using my property and I say, well, no, you've abandoned, I put a fence up. If I'm making that allegation, it is my burden to prove that you stopped using it. It is not your burden to show that you've consented, that you're continuing to use it. Okay. Although abandonment will be presumed if there's an obstruction to it, and it's got to be a physical obstruction. You know, sometimes we've had cases where people say, well, I put up a flower bed. A flower bed really doesn't prevent anybody from using it. A fence does, a garage does, right? And these cases go to trial. They need cross-examinations because they are very detail-oriented. It all comes down to the facts and circumstances. So for these, they're expensive. They're usually done on building construction sites, right? Somebody wants to take a parcel of land, they want to develop it, and then they need a right of way, or there is a right of way, and they want to use that portion of land because you can't build on a right of way, right? And so they want to get it removed. And so they raise all kinds of arguments saying that it's been abandoned. That is based upon evidence, and it goes to trial. So for release and abandonment, that's when you don't have the other party's consent. You want to go to court, you want to get it removed, and there's a lot of work. But we do those types of matters. The third one we talked about is the unity of ownership, where one owner gains title to several parcels, or the parcels that own both the servient and the dominant tenement. If you own both, it will be extinguished at law. And that's because you need two separate owners. And when there's no longer two separate owners, there's going to be no longer differing properties, differing owners, and therefore you have a unity of title, which means that easement is lost into the ether. And then, of course, when you go to remove it, you're going to do it by way of consent and you sign off on it. Why? Because you have the capacity to do so. You own both parcels of land. Very rare do we see a unity of ownership to extinguish an easement. It does occur, but it's rare, but it is one of the ways to get it done and off title. The fourth way is for an easement is to die is by way of statute. Okay. Like I said earlier, under the Registry Act, 40-year searches. If you have an easement that is on your title, you have a positive obligation to re-register that every 40 years to put the world on notice. Section 113 of the Registry Act says if you don't, it's going to be considered of no force in effect. God willing, if your property is a convert from registry to land titles, and you had an easement and it was registered within the 40 years of your ownership, when that property got converted from registry to land titles, the government also brought it over and registered it on title. I have seen situations where we've done a search, they had an easement and the government missed it. It's a small application. It's not a matter of going to court, but it's one of those things that you always want to check your title, no different than your credit rating, I suppose. You want to check on it from time to time to make sure that nothing's been registered on it, or that your rights that you have or that you got when you acquired the property still exist to this day. So if you have a registry property and you have an easement, you want to search title to make sure that it is still there. And then the last way in which an easement may die is based upon the language that provides for if it's a life easement or for a definitive period of time. Some easements do have definitive periods of time, and if there's no clear agreement, the nature of the easement, its purpose, the parties' relationship, and other factors are used to determine whether it is meant to be perpetual or temporary. If there's no date set for expiry, the easement may extinguish itself if the purpose is no longer needed. And without the consent of the other party, which would be an express release, again, you're back to court. Let's be clear. Of the four ways that an easement can be extinguished, one is by way of consent, the rest are by way of, well, two are by consent, an express release and a unity of ownership, and then the other two are done by way of court applications. And I can't stress it enough. You want to avoid court as much as possible. And so we look at the time period and the use of that easement, and is that easement still necessary? Now, easements is an umbrella term. There's a lot of particular easements that fall under that umbrella term. Okay, so one of the most common easements that fall under that umbrella term is the right of way. And a right of way is an easement. It doesn't grant ownership to land. The way you can recognize an easement is when you pull up the registered document, it says a grant or reservation of a way or a road, and it implies an easement. And then once the right of way becomes appertaining to the land, it gets attached to the land, it stays connected until all the original related lands, unless are surrendered or abandoned. And then the non-use of an easement doesn't necessarily mean it's going to be lost. It can be evidence of abandonment, but just because you don't use a right of way doesn't mean you lose it. It's there unless, of course, it was blocked, in which case there's, an argument for abandonment. But right of ways are key. And the one thing I tell people is when it comes to a right of way, it just means passage. It means you have the right to go over it, in and out. That's it. You can't park your car on it. Can't store stuff on it. The neighbor who is giving you the right of way can't block your access. Otherwise, it's going to be considered a disturbance. So those are right of ways. They're just passages. Another particular right of way is the right to air. We all have the right to clean air. And it is a plain common law right to have free use of the air in its natural unpolluted state. What's interesting about the right to air is you can't claim it by prescription. You've had clean air for such a long period of time, they started disturbing it, and therefore, you're claiming an easement by prescription. I read an old case that says that was abolished. It was by statute, unless you've been using it for 20 years prior to March 5th, 1880. And that's going to be a hard evidence to get, because you need live witnesses from over 150 years ago talking about the use of the air. But there is an easement for air. There's also an easement for light. So there's no right to lateral light in common law. So if I have a house here and you build beside me and you build up, which blocks my light from coming into my property, unless there's a written easement, or I've been there for a particular period of time, my neighbor can block it. They can build it and they can block my sunshine. And an easement to light can only be acquired for a building, not an empty lot. So let's assume, and one of the questions would be, well, when did this come up? So let's assume for the moment I'm severing a lot and I'm going to give you the other half of my lot. I would put an easement in there saying, you're going to grant me an easement for light, and you agree whatever you build on your land will not block my light. Okay, that's a negative easement, because I'm not compelling you to do something, I'm compelling you not to do something, right? So that would be in perpetuity, and it would be my easement in my favor for my benefit, provided I'm not vacant land, I actually have a property built. So that is the right to light. And then water. Water is huge. There's easements for water courses, navigable waters, surface waters, riparian rights, floodwaters, and underground. These are particular easements, and they depend on the context and the use of them. No different. It's a part of land, right? And then the other one is rights of support. Okay. This is to do with runoff waters and supportive retaining walls and party walls. You can even acquire a right of support by prescription. So you and I own adjoining parcels of land. I was here first. You come in and you build a retaining wall. Okay. I don't have an easement to that retaining wall, but I've been using it, let's say, for 20 years. Now you want to knock down your building, your property, your structure. And by doing so, it's going to remove the support to my property. I can actually claim an easement by prescription for that support because I've been using it for so long. Okay. Also, natural land cannot be dug by a neighbor so as to interfere with its own support. The bottom line is each landowner has the right to use their own land without interference from their neighbor. We're getting near the end here. So easements are double-edged swords. Okay, they can make a property a lot more valuable by use, right of way, putting restrictions, covenants for water, and for light. The flip side is it can also reduce your value. We're going to talk about this on the next slide, but I'm getting a lot of Hydro One easements, and Hydro One wants to put up poles, and they're incentivizing owners, saying, "Look, we'll pay you money if we can put up your poles and we can put up guy wires." Okay. The property owners are excited about this. I don't know why. They're excited, saying, okay, well, you know what? It's property I'm not going to use, and it doesn't really matter, and I want hydro anyways. I think that's a short-term view, if you ask me. And the reason why I think it's a short-term view is because once that easement is on title, it's on title. We talked about how hard it is to remove it from title, and hydro's not going anywhere, right? And if you own a large parcel of land, ultimately, land gets sold, it gets developed, it turns into builders, right? They turn into developers. It's very difficult to develop when there's that easement that is registered on title. Okay. So it's a double-edged sword. It can be very valuable if you have one. It can affect the value of your property if it's if you are the servient land. So, and they're a big source of litigation, right? And easements are fact specific, and they're lengthy and costly to assert and to defend. So you want to make sure what your rights and obligations are that are registered on title. And on top of that, if someone's asking you for an easement, think twice about it, right? And if you're going to get paid for it, Do an appraisal. I tell people, get an appraisal, find out what the value of your land is without the easement and what the value of your land will be with that easement. Because if that easement is significant, or really may have a future impact on the use of the property in the future, who knows if the money they're giving you today will be sufficient for the sale for tomorrow. So easements are not straightforward issues, and they do require a full title search and the history of their use prior to me being able to come up with any definitive conclusions. I can tell you we're an experienced law firm. We do a lot of real estate. But when it comes to easements, this is really how it goes. I tell people I got to search title. I got to see what's registered. Are we dealing with the registry property? Are we dealing with the land titles? What was the date of conversion? What was registered? Was it kept up to date currently? What was the purpose? What does it say? And then after we've done our diagnosis of the land, if you will, then we can start talking about what's actually happening as between the parties and whether or not there's been a nuisance, a disturbance, or an abandonment. I apologize. So that's a general overview of easements. I hope that I've covered what you're looking for, but we have time for questions, and I look forward to hearing from you all, and I appreciate you coming and listening. Thank you.
Great. Thank you so much, Andrew. We do have some questions in the chat, and just a reminder, if you do have questions, you can type them into the chat here and I'll read them out to Andrew. So I'll read these in order that they were written. First question is, I own a 25-acre bush lot that is landlocked, and am I correct that there is an implied easement across the property of the owner of the front 25 acres? Is there a measurement of how wide an easement is in that situation?
It's a great question. It comes down to the purpose, right? So let's assume for the moment you're only using it for a car. So that easement's going to be about, cars are what, 10 feet wide? You need 3 feet on the other side. It's going to be a 16-foot easement. Going back to the question, an implied easement, that really does depend. We'd have to search title and go back in time from the Crown patent to find out how was that land ultimately subdivided. And if it was subdivided, that should have granted an easement. You can make an application for an implied easement. You would tell the court this is what you need it for. And depending on your uses, that's what the court would grant you in terms of width, if that makes sense.
Okay, thank you. The next one is a two-part question. Can a right-of-way easement be removed by a railway if an agreement cannot be reached regarding the new safety requirements of Transport Canada? And then the same question also asks, if there is agreement for a farm crossing of the railway from 1892, would that agreement still be in place?
Here's the legal answer. It depends. So let's talk about an 1892 agreement. I can tell you, mind you, the Land Titles Act came into effect in Ontario in 1885. It might be a land title property. We'd have to search. Let's assume for the moment it's a registry property and it was registered on title. That thing's got to get registered every 40 years unless it's a public utility. And if it's a public utility, it has to be used. It has to be used at the time and consistently for it to still survive. So again, the answer is it depends. I'd have to search title and let you know if that agreement would still be in place. Talking about the agreement, the question prior, which is I have an easement and they put a railroad over it. Okay. Who granted that railroad? If I am the dominant tenement, so I have the right to use it, and the owner, the easement I have is a non-exclusive easement, and the owner of the property grants CN Rail the right to put down railroad tracks. The next question becomes, is that disturbance material that is substantially interferes with my use and enjoyment of my deeded easement? If the answer is a train got stuck and I can't travel for days, that's substantial. If it's, I got to park my car and I got to wait the 40 seconds or the 5 minutes for the train to pass, I think it's going to be a very difficult argument to say that your easement is being interfered with. So I hope that helps, but I'd have to take a look at it, but that's the general idea.
Great. The next question is a water prospective rights question. I have a 21+ year handshake agreement with my neighbor that my egg tiles cannot outlet into their private ditch. My neighbor sells the property and the new owner does not want to accept my water anymore. If both properties were under their registry system, I assume I can apply for prospective rights. What happens if the sale of the neighbor's property was under the land title system?
Great question. So here's the thing, handshake is only good for the person you have the handshake with. That handshake does not extend to their executors, to their children, to anybody that they sell. The problem with, in order to get a prescriptive easement, you can't be getting it with the consent. If you remember, we talked about a neighbor allowing his other neighbor to park the car, or you can park on his driveway. The individual sells his property and the new owner tells the other neighbor, get off my land. I could care less what the predecessor in title gave you. You can't park your car anymore. If there's an argument that he was being a friendly neighbor and you had permission, you won't be able to get it. So I don't know if the original owner is still there, get it registered on title. If those water rights are that important to you, it may come down to an economic question as to what are you prepared to pay for it, and have it registered on title. In all likelihood, the properties are converted into land titles. So once it's there, you don't have to worry about the 40-year business, and just get it registered and get it kept on. That's the way I would deal with it. Handshakes are only as good as long as that person is honorable and they're still alive. You lose those two things, you're going to have a real problem enforcing that handshake.
Great answer, thank you. And I think that kind of leads into the next question here. So, is it common for easements to be paid for? If so, is it typically on an annual or one-time payment? If it is annual, can defaulting on those payments lead to dissolution of the easement?
Another excellent question. So generally speaking, easements are paid for with money. It is a one-time payment for the most part. So if the easement says we got to pay you every year for it, to me it sounds more like a license, a continual license than an easement, because they're supposed to run with the land. It's usually a one-time payment, and it depends on what you consider a lot of money. I don't consider it to be a lot of money. I've had TTC take a portion of my client's property. They gave him $3,000 for these hydro poles. The one that I have now on my desk, they're offering them $8,000 to put up as many poles and as many guy wires as they want. And it stretches over, I'm going to say, a half a kilometer. Like, to me, it's a major interference. So no, they don't pay a lot of money. Now, that's Hydro One. That doesn't mean you can't squeeze them. I've had cases where I had a major corporation. They were building a hotel and they needed to connect to a water main that was under my client's property. It was a municipal thing. And so they wanted the right to connect and to go on the property. And they did what I expect them to do. They knocked on the door. They said, look, what we want to do is very small. There's not much to it. Give you $2,000. And then, my client comes to me and says, this is what they want to do. They're offering me $2,000. And I said, get an appraisal. Get an appraisal as to the value of your property with or without it. And then we actually turned to the hotel operator and said, look, we're not laying our money out of pocket on this. You need to pay for the appraisal before we even get this. And what was so interesting was we actually gave enough pushback that the hotel said, forget it, we're going to go somewhere else. Well, yeah, because once they connect their water main, they don't care about you anymore, right? So the money is not, it's not big money. It really isn't, which is why I always say you have to sort of run the numbers, if you will, and it's part of negotiation, right?
Great, thanks, Andrew. So we do have a few more questions if you're still okay for a few minutes.
Absolutely.
Awesome. Next question. Can you briefly speak to the working area around a municipal drain built under the Drainage Act? I've heard the working area referred to as a form of easement.
Yes, because I have to see what's written, but the court's going to impose reasonableness to it. So if we have a water drain, let's say it's a 4x4, and we have to do work on it, what is the reasonable area of space around it in order to engage in the work. Now, keep in mind, that doesn't entitle the service workers to destroy the property. They have to restore it back to the way they found it. But how long are they going to be on the property for, right? So, yes, there would be a presumed easement. Actually, you know, I would think that the recorded instrument would say they have the right to work around it, if you will.
Okay. Next one is, in the case of a pipeline easement in perpetuity, is there any precedent for further compensation due to increased value of the land and increased liability? Easement dates to 1920s. They're talking about a specific one that they're saying is 100 years old.
I had one. It was a sewer line that went under my client's property. It was such a mess. It was such a mess. Anyways, no, we couldn't get more money. Number two, they had the obligation to repair it. And number three, I'll tell you an example. I had a client that was buying a parcel of property and they wanted to put in a swimming pool. And there was a sewage pipe that went diagonally through the backyard. I said, you can put in the pool, but the problem is this, the easement rights are already there and they have the right to maintain. So what will happen is they will come onto your property, they will rip up your pool, they may charge you for it. They're going to fix their pipe and then they're going to take the machinery and they're going to take it off your land. And then you're going to be stuck with the cleanup. So if the easement is already there, pull the easement, see exactly what it says. It might be for a short period of time. It may provide for notice in advance. I have a few that I'll say, here are all the rights and obligations for the easement, and they're detailed. Like it's like a 4-page agreement that talks about it. So on that pipe, you'd have to take a look to what it says. No, you won't be able to get more money. And if they have to repair it, it's going to be on their ticket. And they have to put your property back to the shape it was prior to them ripping it up for them to do their work.
Okay. Next one is another two-parter. Looks like there are two questions from the same person. If we have a right of way on the adjoining property to the acres, to access their driveway, do we have to worry about abandonment? And they also then put, are you being consulted by any of the law firms surrounding the St. Thomas EV plant?
So, okay, if anybody wants to contact me, really what happens is you shoot me an email. It's easy to find me online, Andrew Fortis, Hummingbird Lawyers. We run a conflict check. Most of the work that I get is north. I don't get a lot of work Windsor, London, Ontario, or out east, Kingston. For one reason or another, I happen to be just sort of like in the center of the province, so it goes up. We'll run a conflict check and we'll tell you if we're able to assist on that. So, but repeat the first part of it again, Ben.
Sure. So the first one is, if we have a right of way in our adjoining property to access the driveway, do we have to worry about abandonment?
You have to worry about it if they block it. If they put up a structure that prevents your use and enjoyment of it, that's when you have to worry about it. Remember, non-use is not abandonment. It's a hint, okay? But when we talk about non-use, it's got to be like 20 years. Like, it's got to be a long period of time. If you don't use a right of way for, let's say, a year, that doesn't mean you give it up. If you're not using it for a year and they put up a fence, that's when the argument for abandonment would come in.
Gotcha. Okay, we have two more questions here. This one is, how does liability work for lands governed by an easement? For example, someone who slips and is injured while accessing their right of way on another person's land.
So, great question. I've seen it. Anybody ever slips and falls on a property, they sue everybody. The personal injury lawyers will sue everybody. They will sue the adjoining land and the owner. Have insurance, okay? And that's another problem with these things, is because it's the insurance. So what ends up happening is, let's assume for a moment you have a right of way on my property, okay? So I'm the actual title owner. Ben, you have the right of way. You decide to have a dinner party. You invite guests over. They come on that right of way. They slip and fall. The personal injury lawyer is going to say, where did you fall? They're going to search title. They're going to see it's registered under my name. They are going to sue me. I, in turn, tell my insurance company to sue Ben's insurance. And then they just take it off the court, and that's where it goes. But If I am found liable for it, right, there's going to be an increase in insurance premiums, which is why, as part of the easement, you want to make sure that there's language in there that says, Ben agrees to have insurance, Ben agrees to provide me with insurance on a yearly basis, and Ben agrees to indemnify me for any loss, claims, damages, you name it, the whole laundry list that may arise out of anything that may occur by his invitee, tradespersons, service persons, what have you. That, so you really want that in the agreement.
Great. And then the last question here is they're describing a situation of a power line installed in 1910. The line was repoled in 1954 and then again in 2006. It currently runs 500 meters across the property and easement is on title. Should there be compensation for that?
I have 2 of these files, okay? So the problem is the compensation is usually delivered at the front end. So compensation may have been delivered in 1910. And then it's there forever, which is that's one of the issues with the easements, is right, they're there forever. Now, without looking at title, I asked myself, what did that original 1910 agreement provide for? Sometimes when it comes to hydro power lines, it says how many poles and how many guy wires. Did they expand it? Right? Did the easement say it allowed for 5 poles, but now they've put up 20 poles? Have they expanded? If they expanded it, then they would either have to, I would use as a negotiation tactic. Either you need to reduce it or you need to remove them. And if you don't want to reduce them or remove them, you now need to pay me for this expansion of the original rights that were there. But I'd have to search title and see what was there. But off the top of my head, that's the advice I would give.
Excellent, thank you. And that is the end of the questions that we have. So I'll wrap up by saying thank you so much, Andrew. This was extremely informative. And a reminder to everyone on the call that the replay of the webinar, if you know anyone who missed it, will be on our website and our YouTube channel within the next few weeks. Thank you to everyone for attending. And again, thank you, Andrew.
Thank you. Thank you for inviting me. Thank you.
Okay. Have a great day, everybody.